So I'm honored today, very honored today, to welcome our Deputy Attorney General, Sally Yates, to the ABA's annual National Institute on White-Collar Crime. On this 30th anniversary, again, thank you, Ray. Sally has been our Deputy Attorney General for a year. Seems like longer. But her impact during the last year has just been quite remarkable. For anybody who knows Sally, they know she is a person of great energy and with a passion for justice that has brought her to her position that she holds today at the Justice Department. Her leadership in the field of criminal justice began during her tenure as an AUSA in the Northern District of Georgia, where she honed her skills as a real trial lawyer, which is important. And she gained national recognition for her public corruption cases, as well as her prosecution of Olympic bomber Eric Rudolph. Sally was first assistant U.S. Attorney in Atlanta before being confirmed as U.S. Attorney in 2010. As a fellow U.S. Attorney, I saw Sally become one of our leaders. She was the person who we wanted to take the message from the field, where, for all of us practitioners outside of the district, where the real work of the Justice Department happens. We trusted Sally, sorry, Leslie. We trusted Sally to take that message from the field to the leadership at the Department of Justice. We trusted her good common sense that came from being in the trenches, her sense of fairness, and her understanding of the complexity of criminal justice. Sally and I have known each other for many years, and over those years we've had many, many discussions about our work in criminal justice. I know that Sally considers it to be her privilege to represent the people of the United States in the Department of Justice, but we are lucky to have a person of Sally's experience and her compassion in a position of such importance. So now it's my privilege to welcome my good friend Sally Yates to this conversation. Welcome to Between Two Ferns.
Or Between Two Palms, maybe, instead of ferns.
So rather than a speech, very graciously, Sally offered to have a conversation in the form of some questions and answers on the Yates Memo. So we'll do that now. We're going to walk through its origins and some of the concerns that folks in the white-collar defense bar and corporations have. Sally and I are two Southern women, and we may make liberal use of the word y'all, both in its singular, as in, hey Sally, how y'all doing? And in its plural, also sometimes spoken as all y'all. So are all y'all ready to go? Okay, good. So Sally, let's begin. You want some water?
I think I'm okay so far,
okay.
But yeah.
Just want to get you started correctly. So
I think I am kind of glad, though, of all the times that I felt like I needed a security detail, this event might be the one. So.
Where are they? Yeah, okay, we're good. And you've got Leslie in the front row.
Exactly, yeah.
Sally, for many, many years, the prosecution of individuals in corporate cases has been an emphasis at the Department of Justice. Indeed, there are many, many speeches by the leadership of the department, including Eric Holder, including the leadership at the criminal division, beginning with Lanny Brewer, Leslie Caldwell, Marshall Miller. Each have made speeches about the importance of individual liability in corporate cases. So that being said, what was the process that led you to the decision, or y'all, to do a decision, or to make the decision to do a formal memo and revise the USAM?
Well, Anne, you're absolutely right that the concept of doing everything we can to hold culpable individuals accountable is not anything new at the department. That's been something that department leadership, both in the form of former leadership, Eric Holder and Lanny Brewer and Mike Lee Rahman, and current leadership now, Leslie Caldwell, even well before we ever did this memo. This was certainly something that all the leadership of the department has been committed to. But I think really more importantly than that, the line folks at the department have been committed to this. The line AUSAs who do the work and the line department prosecutors who do the work. And I think that this commitment comes from what may seem like obvious things, but because we know how important it is that we do everything we can to hold culpable individuals accountable in the corporate arena. And we know it's important for the deterrent value that it brings. My friend Larry Thompson used to talk about how there's nothing that deters corporate misconduct like the concept of somebody going to prison, and that's true. We know that holding individuals accountable is the best way to be able to really change corporate conduct. And we also know about it from the basic fairness standpoint, that it's important that the public have confidence in their Justice Department and their criminal justice system. So we all know it's important, but we also know it's really hard too. In these cases, these are complicated cases. And in the corporate structure, knowledge is oftentimes diffuse, and it's hard to sort of figure out who knew what. And trying to piece together these cases oftentimes means going through millions of documents, and even there, the kind of information you need about knowledge and intent oftentimes isn't in documents. So we know it's really important, and we know it's really hard. So not long after I joined the department, we got together a group of the department leaders, all the component heads at the department of the different litigating components that are involved in this arena, including everything from crim and NSD and tax and ENRD, as well as representatives from the U.S. attorney community, U.S. attorneys, to sit down and talk a little bit about how we're approaching corporate cases, and specifically how we're approaching our efforts to hold individuals accountable, culpable individuals accountable, and to look at the things that we're doing really well in some parts of the department, and to try to ensure some consistency across all of the department in those practices, and then to examine whether there's some things that we should do differently. And so we put together this, because it's Washington, so you got to have a working group. So we put together a working group, and I met with this working group over the course of, I guess, about 4 or 5 months. And then there was a staff level working group where all the real work gets done, and they met as well. And we met every few weeks talking about different aspects of this process, of everything from what we should be doing in the civil arena with respect to individuals, to waivers, to the whole issues across the board. And the memo that came out in September was a product of that discussion. It was really, even the drafting was a product of that working group. So that was a rather long-winded answer to that question. I'll try to keep it shorter for the others.
It's okay, it's your world.
Yeah.
So, Sally, you must be disappointed that not very much has been written about the Yates Memo.
Yeah, I'll confess I haven't read every single client alert that's gone out on this. And I'm going to try not to say anything newsworthy, so there won't have to be any other client alerts after this. You guys should enjoy San Diego rather than pounding out another client alert on this. I haven't read all of them. I've read some, though, and I've certainly read some of the articles. And it does seem like that there's sort of a range of reactions from the shrug of, this is what they were always doing, what's the big deal, to this is absolutely Armageddon and criminal justice will come to a halt. And I think the fact of the matter is the truth is probably somewhere in the middle of those two things.
So that is actually what some of the client alerts say, that this is a big game changer. And others have said business as usual. So where is that?
I think it's in the middle. I think the concepts that really undergird all of the policies that are in the memo are concepts and practices that have long been part of the Department of Justice. But there are some specific things that we wanted to make sure that we were doing consistently across the department, and there are some things that we're doing differently that are memorialized in there. So I guess, I think it's somewhere between those two. Yeah.
One area of concern for the Defense Bar and Corporate Counsel is defining the scope of investigations. So given the particular focus on identifying culpable individuals and defining the scope of the investigation has become much more difficult. So how can we be sure that our internal investigation is sufficiently complete?
Yeah, this is something certainly that I've read about as a concern, and even before we issued the policy, and I call it the individual accountability policy. I can't call it the Yates Memo because frankly that creeps me out. But before even that, we talked about this concern. And in fact, Leslie Caldwell and I had some discussions about this, and we wanted to make sure that lawyers and companies knew that what we're looking for here is not that you go out, in Leslie's term, and boil the ocean. That's not what we are requiring or expecting or wanting in this. What we're expecting you to do is to go out and to conduct thorough investigations that are tailored to the scope of the allegations of wrongdoing in this particular matter. And if you have questions or concerns about what's required, and I understand anytime there's a new policy, there's naturally some anxiety about sort of how is this going to be carried out in the field. And so we get that there can be that anxiety there, and we want to help with that. And so if there are questions about what the appropriate scope of the investigation should be, we would encourage lawyers to do what they've been doing for a long time, and that is to pick up the phone and call the prosecutor and talk about it, and talk about what your suggested scope of the investigation is, and to see if that comports with what we have in mind. Now, you don't have to do that. We're not going to try to dictate to you what the scope should be, but if you have uncertainty about that, those are conversations that we're happy to engage in.
All right. So as I noted previously, former Attorney General Eric Holder and others in leadership at the department have spoken about the importance of individual liability in corporate criminal cases, but have also noted the difficulty in identifying culpable individuals. So what if, in your internal investigation and our internal investigation, you do everything that you can to try to get to the bottom of the facts of things, and you cannot figure out or determine who did what? Are you out of luck for cooperation credit?
No. There's a good faith element of this that I think really is a gloss on every DOJ policy and really everything we do. And we tried to make very clear, both, for example, at a training conference that we did that was the week after we issued the policy, we brought in AUSAs and lawyers from all of the litigating components into one training conference so that we could talk about implementation of the memo. And I spoke there and made it really clear to folks there that if a company truly, despite their earnest best efforts to do a reasonably tailored investigation, just for whatever reason can't figure out who did what, and we are satisfied that they've acted in good faith and done everything that they can, then they are still eligible for cooperation, even if we don't know the specifics of who did what. Now, we would expect this to be a relatively rare occurrence. We don't want this to be the exception that swallows the rule, but we do recognize that there can be instances where this occurs, and as long as, again, as you've done a thorough, reasonable investigation, and you've done what you can to overcome whatever obstacles you may have in being able to figure out who did what, and that's all we're looking for is who did what, then yes, so you're still, of course, you're still eligible for cooperation credit. We also, just to underscore this and beyond just training, made sure that we included that factor in our written policies, and the revisions to the USAM specifically lay all of that out as well.
Okay. So let's talk a little bit about attorney-client privilege. There's a long history of DAG memos with policy adjustments related to the attorney-client privilege and internal investigations. And that's been a source of much discussion about the Yates Memo. So does the policy, the Yates Memo, change the department's thinking on attorney-client privilege?
No, it doesn't change our thinking on attorney-client privilege. And look, I also understand and get how there can be anxiety in this area as well. We've tried to be really clear, though, that the department's policy hasn't changed on this. And the policy itself specifically states that companies are not required to provide privileged information. In the speech that accompanied the policy when it was first announced, I tried to make that clear. In another speech later at the American Banking Association, laid that out. And the Phillip factors that are there, and there's a section there that goes on at great length about the implications of privilege, specifically in the context of internal investigations. We didn't change that, still not required to provide privileged information. Also, didn't change anything about the fact that you're not allowed to ask for a waiver of the privilege or to require a company to waive the privilege. And then on top of that, when we issued the USAM changes, just so it would be clear, we actually put a sentence in the USAM that said, to be clear, you are not required to waive the attorney-client privilege in complying with the requirements of providing all facts about individual conduct. So I understand that this can be more complicated now. I'm not going to be naive enough to say that I don't appreciate that this may be a more complicated area for you all to navigate, but our expectation about waivers of the privilege has not changed. We are not requesting, nor are we requiring any waiver of the privilege to satisfy this cooperation requirement.
All right. Now, as you sort of just noted, that sometimes the devil is in the details on policy shifts like this. So I want to ask you a couple of more detailed questions about the all or nothing component, which is also a subject of of great discussion. So does complete cooperation require a company to impose some type of disciplinary action against a current employee who either refuses to be interviewed or refuses to sign a tolling agreement?
No, we're not, to satisfy the cooperation requirement, we're not requiring you to take any specific personnel actions with respect to company employees. That's not part of the cooperation requirement. Now, there are other factors, though, beyond just cooperation that we consider in the Philip factors, and one of those is remediation. And certainly in the remediation factor, whether a company has taken disciplinary action or removed an employee, a culpable employee, is something that we look at. But that's a separate factor, and that's not, for example, for employees who refuse to be interviewed.
Right.
That's for companies, for employees that have been determined to actually be culpable. We would look at that for remediation, but not for cooperation.
Okay. So, but you are looking at what a company does in terms of taking action against a potentially culpable individual.
We're looking at it the same way we always have.
Okay.
This memo doesn't change that at all. That's always been a factor that we've looked at.
Are cooperating companies expected to take a view of the legality of individual conduct?
Now, this is one that seems to come up a lot in the articles and client alerts and all that I've read. No, we're not expecting companies or lawyers to do that. At the risk of sounding like a broken record here, we want the facts. What we want to know is who did what. And we expect a company, if they want credit for cooperation, to provide those facts to us. We're not expecting you to build prosecutable cases against any individuals. We're not asking you to designate any of your employees as criminally or civilly culpable. We're asking you to give us the facts. You don't have to pen any scarlet letters. You don't have to build any cases. We're not deputizing you as AUSAs to put our cases together. We just want the facts.
You want the facts, but associated with individual conduct when possible.
Yeah, I mean, we consider that the complete facts. And you know, that's one of the reasons why we did this policy, is that, you know, it's long been the policy and the practice of the Department of Justice to require companies, when they want credit for cooperation, to give us all the facts about what the individuals did. That's not anything new. Go back and read the Philip factors. It's been there since 2008. That's not new. But what we found is sometimes we were getting that, and we were getting that full kind of information about who did what. But some other times we were getting sort of what I would consider sort of that passive voice kind of presentation of mistakes were made, and you get sort of the general description about what happened in a company, but there's no description at all about who did what. And so the purpose of this is essentially to explain to folks, we really mean it when we say, if you want credit for cooperation, you've got to give us the facts about what individuals did. So the requirement really hadn't changed, but the consequence of not doing it has changed.
In FCPA cases, there are some potentially added complications. For example, situations where a U.S. company has exposure, but all of the individuals who engaged in the misconduct are potentially unprosecutable, either because they reside in no countries with extradition treaties or extradition is difficult. So in practice, if a corporation provides information about those individuals, can it expect to receive as much cooperation credit as a corporation that provides all the relevant information about easily identifiable individuals in the United States?
Sure. Again, you don't have to give us a prosecutable case. We're not looking for corporate heads here. We want the facts. And so it doesn't matter if the person is within our reach to be able to prosecute them or to bring a civil case against them, or whether they're, you know, outside the bounds of our extradition treaties. As long as we're satisfied, and we do need to be satisfied, you're giving us the information about all of the individuals that were involved, that's all we're looking for. And you also don't have to produce somebody that's culpable. You know, our goal here is to figure out who did what. It's not necessarily to find an individual to prosecute. It's to figure out whether there are individuals that should be prosecuted, or whether there are individuals who should be held civilly responsible for it.
All right. Now, some people are suggesting that the all or nothing requirement actually creates a disincentive for companies to cooperate because of the unpredictable outcome for their efforts. So what are your thoughts about those type of comments?
Yeah, I've read that too. And I guess, this one's sort of,
I think I might have written one of those.
Yeah, I think you probably did. You wouldn't be the first person. To me, this one sort of illustrates the difference between what I call sort of the blogosphere world of reaction to this memo and maybe the real world. In the blogosphere world of client alerts and articles and all of that, I've seen that where they say, now it's just, it's too onerous a burden to have to provide all the information about all the facts, and companies won't want to cooperate for this. In the real world, though, at least so far, and it's only 6 months in, we haven't seen that happen. We had a meeting just a couple of weeks ago where I brought together all of the component heads to find out sort of how was implementation of this policy going. What are maybe some unforeseen difficulties or consequences that we hadn't thought about that we might need to adjust or tweak, and are they having problems with this? And one of the things I specifically asked them, in part because I'd read some of this, was, are you guys having companies refuse to cooperate with you now? Or is anybody shutting down maybe who had been cooperating before? And to a person, every component, including representatives from the U.S. attorney community there, said it hadn't happened. They haven't had a single company decline to cooperate. And sort of more surprisingly to me was they hadn't really even in the real world had companies or lawyers really complain about this that much. Now, that doesn't mean the complaints won't come, and that doesn't mean that that we won't be reading more about it too, but at least so far, at least it looks like there's a little bit of a disconnect between commentary versus what's happening in real life. And at least as far as the cooperation of companies, that doesn't entirely surprise me. While I can expect there may be circumstances, and look, maybe there could be some going on right now I just don't know about, but there could be circumstances where maybe a company decides because of this requirement that they're not going to cooperate. But, that's really hard to imagine that it's truly, at least very frequently, going to be in a company's interest to decide to forego the really substantial benefits that are accorded a company that cooperates simply because they don't want to tell us the facts about who did what. And that seems even more unlikely in the context of a publicly traded company, because it's hard to imagine that would really ever be in the interest of the shareholders. So while that could happen, we haven't seen it yet. Now, where I think where there may be a little more room would be in the areas of voluntary disclosures. And that might be a situation where there are companies who decided not to disclose, potentially because of this policy, and we just don't know it since they didn't disclose. And I'll grant you that could be happening. Again, we don't have an indication of that yet, and it seems to me that the decision about whether to voluntarily disclose would more likely be based on whether you think we're ever going to find out about that conduct more than about the requirements of the policy itself. And I think that's particularly true when we've tried to create, and we can talk about this later if you want to, a greater incentive for companies to voluntarily disclose now by separating out the factors of voluntary disclosure and cooperation so that there can be a greater gulf in the benefit that a company gets between those who just cooperate and those who raise their hands and voluntarily disclose.
Well, let's talk about that then.
Okay.
So for those of you all who have a copy of the USAM or a red line copy, you'll notice that there is in the Federal Prosecution of Business Organizations the section that we call the Philip factors to be considered, regarding the decision to either charge a corporation, negotiate a plea, or the other types of agreements. There were changes made to the Philip factors. And in those, you specifically separated the factor regarding a corporation's willingness to cooperate in the investigation from the voluntary disclosure, and made those into two separate factors. So describe for us what went into that decision to separate that one sentence into two separate factors.
Well, as we were having all of these discussions in the working group about cooperation and what that includes, we realized as we focused on this that really voluntary disclosure and cooperation are two separate. They're related, but they're two separate things. And it's quite a different thing for a company once we're onto them to agree to cooperate after we've already figured it out, versus a company that literally raises their hand and voluntarily discloses and tells us about criminal conduct that we didn't know anything about to begin with. And we feel like the company that voluntarily discloses and then cooperates should get a lot more credit than the company that just cooperates after we've already figured it out. And one of the ways to make sure that that happens is to make sure that we have an independent analysis, both voluntary disclosure, and to have that be separate from just cooperation, so we can be sure that there is a greater gulf. We want to incentivize companies to come in and voluntarily disclose, and having a greater gulf in the difference in the credit that you get seems like one way to do that.
So when the internal investigation is complete, all the relevant facts have been disclosed, you all agree that the company qualifies for cooperation credit. What happens next?
We pressure test it some because just as, again, this isn't new, it's what we were and should have been doing all along, is that we're not going to just sit back and take the result of an investigation and not be doing our own investigation. And we should be doing it contemporaneously with yours, hopefully in a way that's not bumping into you as you're doing your investigation. But the first thing that we would do is pressure test it and make sure that we feel comfortable that we've actually gotten all of the factual information about who did what. And then when making the decision about how much credit to accord for the cooperation, we would use the same kind of factors we always have. The providing us all the information about who did what is the threshold factor, that gets you in the door to cooperation. But then once you're in the door to get credit for cooperation, we look at all the other factors we always did before, like the timeliness, how quickly did you begin to cooperate? And then once you were cooperating, how quickly did you provide the information to us? How you're producing documents to us, whether you're making employees available to us. We look at all of those same factors we always have in determining how much credit you get for cooperation.
So one change that I think everyone can agree is a significant change, potentially a game changer, is the policy that relates to individual civil liability. And the ability that ability to pay takes a lesser role in the decision to bring a lawsuit against an individual. What was behind the decision to make that change?
And internally, I think that change has been the subject of more discussion than any of the other ones. It might be different than, for example, externally, the all or nothing provision certainly has gotten the most attention. But internally, it's really been our shift in civil focus. And the idea there was along the lines of what I just mentioned before. If we look at the purpose of both civil and criminal cases being beyond just recovering the most money from the most corporations, if we look at the Department of Justice and what we're doing, and the reasons why we're doing it, to deter misconduct and to try to make change within corporations and to hold culpable individuals accountable, those purposes are satisfied by civil action in addition to criminal action. And certainly the ability to pay is a factor that we should consider in how we use our resources, and it's still a factor that we consider. But it shouldn't be the sole determinative factor in how we use our resources. So what we've shifted now is that we look at the same things on the civil side that we've always been looking at on the criminal side and determining whether or not we're going to look at an individual civilly. And that's the same kind of factors that everybody here is used to in terms of the scope and the seriousness of the wrongdoing and the position that the person held and what their history was. We look at all of those factors in addition to ability to pay and making the decision on whether to pursue individuals civilly. Another reason why we did that is that as we talked in this working group about some of the obstacles that we face and being able to hold culpable individuals accountable, we realized that one of the problems is that if we investigate a case civilly and we are focused just on the company and we go for years investigating the case civilly, and then at the end of that we decide, okay, now we're going to look and see whether or not there are any individuals who should be prosecuted criminally, that's just about impossible to do. Once you have investigated a case from the perspective of looking just at the company, and you haven't been doing the interviews with an eye toward individuals, and you haven't been really reviewing the documents with an eye toward individuals, it's pretty much impossible to unravel all of that and then try to determine whether there are culpable individuals that should be prosecuted. So part of the goal in this is, since a lot of times corporate matters can begin on the civil side before they transition to the criminal side, even on the corporate side, is to ensure that our civil AUSAs, when they're initiating the investigation, are looking at individuals from the very beginning, because that was one of the really important steps that we thought were important in going forward in how the department treats individuals and how we investigate individuals, is that we need to be looking at them from the very beginning of the investigation and not at the end.
And in terms of how this plays out in the field, I think there's been a lot of concern about how that pits a company against individuals in the company, or the perception that that pits a company against the individuals. So I know it's hard for you to predict, but was that part of the consideration? Because you made it a point to say, no matter where they are in the organization, which suggests that this policy is being pushed down potentially to the lowest levels in the organization. So can you talk about whether or not that played a role in the individual liability?
Yeah, I mean, we talked about all of these factors. And again, I know I sound like a broken record. What we want and what we expect from companies, if they want credit for cooperation, is that you all give us all of the facts. And that's all of the facts about the CEO of the corporation and all of the facts about the person who was involved, who's at the lowest level as well. And then it's up to us to make determinations about whether it's appropriate for us to bring charges or to pursue individuals criminally or civilly. And I guess sort of the bottom line here is I don't really think that's a decision that corporate counsel seeking cooperation should make in terms of who we need information about. We need it all. But then we are required to use good judgment in making decisions about whether their conduct is such that they should be held criminally or civilly responsible. And certainly looking at where somebody is in the chain of the corporation would be a significant factor that we would consider there. If you've got, some big multi-billion-dollar fraud, and the only individual we have is somebody who's really way low on the chain, that might not counsel in favor of pursuing that individual there. And so that's a factor that we would consider.
All right. So can you talk a little bit now about how the policy is being implemented across the department, both from the litigating divisions to U.S. attorneys' offices around the country?
Well, after we issued the policy, as I mentioned a few minutes ago, we held a training conference because we didn't want to just sort of fire off the policy and then expect everybody to figure out what to do with it after that. So we held a training conference with, as I mentioned, representatives of all of the U.S. attorney community and the litigating components to talk a bit more of the nuts and bolts of how we're actually going to implement this. And then each component has done training in addition to that would be tailored really to the specific kind of factual scenarios that they would encounter given the types of cases that they are pursuing within their components. It's hard to lay out, and I know that one of the concerns has been, they're not really sure the defense counsel aren't really sure of what's going to be expected. The fact of the matter is, it's really hard to lay out a laundry list here because what's expected is going to be really so fact-specific to each individual case. But what we have been doing is training both initially at the component level as well as certain parts of the policy require things to be memorialized, decisions to pursue individuals and decisions not to pursue individuals. And having the rigor of that requirement that things be memorialized is there so that we can ensure that people are making thoughtful decisions and those decisions are reviewable as well.
Well, Sally, we appreciate your willingness to come here and talk to us again about the Yates Memo and how it plays out over time. It's obviously an area of great concern for those of us who practice in the white-collar space. So we appreciate your willingness to keep beating the horse and helping us to understand it and implement it with our clients. So, final words.
And I've enjoyed being here. And also want to let you, I will be around the rest of this afternoon. And to the extent that any of you all have thoughts or suggestions or concerns, Matt Axelrod, my pay DAG, is shaking his head saying, no, don't do it. No, but I would certainly be happy to discuss that with you. I don't think this is really the appropriate place to discuss specific cases that you might have, but if you have thoughts about, Matt is shaking his head yes now. So I don't think that this is the place for specific cases, but to the extent that you have things that you think I ought to know about the policy and how it works in real life on the defense side, I would really love to hear it. So thank you for having me here today and look forward to being able to talk with you guys.
Thank you very much.